Companies use forced arbitration to prevent workers from taking their employer to court when they are sexually harassed. When bound by a forced arbitration clause, an employee who suffers sexual harassment in the workplace has no choice but to resolve the matter through a secret proceeding where the deck is stacked against them. Arbitrators, who are like privately paid judges, are often picked and paid for by the offending company. Since the rules that allow workers to collect and present evidence in court don't apply in arbitration, workers don't get a fair chance to prove their case. And once the arbitrator has made a decision, it is nearly impossible for even clearly wrong decisions to be reversed. In July 2016, Gretchen Carlson filed a sexual harassment lawsuit against Fox News chairman Roger Ailes in the Superior Court of New Jersey, confirmed on her Twitter account that she was no longer with Fox News. In her complaint, Carlson alleged that she was fired from her program for refusing Ailes' sexual advances. Ailes at the time claimed the accusations were false, while the law firm representing Carlson claimed 10 other women had contacted them to speak of Ailes' behavior at Fox News. Carlson's allegations received widespread media coverage. After Carlson came forward, 6 more women spoke to New York Magazine, alleging that Ailes had sexually harassed them, and that Ailes spoke openly of expecting women to perform sexual favors in exchange for job opportunities. In the case of sexual harassment, an employee would have a difficult time finding out if a manager had a history of preying on female workers based on the limited information that arbitration firms have to report. The workers who are forced into arbitration are often required to sign non-disclosure agreements as part of the settlement, so they are forbidden by law from talking publicly about the case. Even if an arbitrator decides that a boss did illegally harass an employee, that boss could continue to harass women in the same company or at another job without his behavior coming to light. Shortly after her suit was filed, Carlson sat down for an interview with the New York Times and said, "I want to stand up for other women who may be facing similar circumstances." After Ailes finally resigned in July 2016, Carlson said she felt relief that now I would be believed. Carlson testified about arbitration agreements before the House Judiciary Committee. Carlson urged lawmakers to take up a bipartisan bill to end arbitration for sexual harassment cases that was introduced into the Congress last year. It has since been reintroduced in the House and passed. Carlson said, "It turns out it's not just courage that's contagious, so is action."